All right, hello. This is an attempt numero dos to read the Canadian Bill of Rights. And the first attempt was a bit of a failure because I went long and the screen capturing aspect of my setup didn't actually capture the screen, foolishly. Okay. So let's see if I scroll this. Does it actually scroll the screen? Yes, it does. A little bit slow, but you can see that it's scrolling to the top of the page. Now I have tabs open to Justice Laws just for the front page. There's a lot of content in here linked to news about COVID-19 legislative measures. Well, that's kind of rooted in what I'm dealing with. But I've looked at a whole lot of these, and let me tell you, the Income Tax Act is really long. The Canadian Bill of Rights is cited in a lot of laws, legislative acts, but it itself as a standalone piece is interesting to know about. And the critical points, if you were going to look at laws from a divine or eternal perspective, philosophical perspective that expands beyond just what is logically or legislatively the law, the expression that's codified, the codification, that's what I'm trying to say, of philosophy and the law, which you could consider from a Platonic perspective, in text for us to understand as the guiding way. The right, it shows that there are, you can look at laws and you can just think about how they can be abused, and it's right here. And it was, as was the Emergencies Act, abused unlawfully. So, the Canadian Bill of Rights, 1960 C-44, assented to 1960 August 10th. An act for the recognition and protection of human rights and fundamental freedoms. I'm going to say note if I want to say something that later on, but I'm not going to interrupt too much. I'll try not to. Preamble. The Parliament of Canada affirming that the Canadian nation is founded upon principles. It's founded upon principles that acknowledge the supremacy of God, the dignity and worth of the human person, and the position of the family in a society of free men and institutions. Men being genderless, men being humanity, men as in people. Affirming also that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values and the rule of law, and being desirous of enshrining these principles and the human rights and fundamental freedoms derived from them in a Bill of Rights, which shall reflect the respect of Parliament for its constitutional authority, and which shall ensure the protection of these rights and fundamental freedoms in Canada. Big note. Therefore, Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. Part 1. Bill of Rights, major section. Just to advance and understand, part 2 is this little bit, and this whole thing is the whole Bill of Rights. Oh, pardon me. The Bill of Rights is only part 1, which is sections 1 through 4. Part 1, the Bill of Rights. Recognition and Declaration of Rights and Freedoms. Section 1. It is hereby recognized and declared that in Canada there have existed and shall continue to exist without discrimination by race, reason of race, national origin, color, religion, or sex the following human rights and fundamental freedoms, namely, these are the fundamental rights and freedoms. The right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. B. The right of the individual to equality before the law and the protection of the law. C. Freedom of religion. D. Freedom of speech. E. Freedom of assembly and association. And F. Freedom of the press. Now, second section, after the recognition and declaration of rights and freedoms, we have construction of law. Now this governs, so this is what you have as the recognition and declaration of rights. This is how Parliament will construct laws. Every law of Canada shall, asterisk, unless it is expressly declared by an act of the Parliament of Canada that it shall operate, notwithstanding the Charter of Bill of Rights or Canadian Bill of Rights, every law shall be so construed and applied as to not abrogate. It shall be so construed and applied as to not abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared. In Section 1, and in particular, no law of Canada shall be construed or applied so as to no law in Canada will authorize or affect the arbitrary detention, imprisonment, or exile of any person, or impose or authorize the imposition of cruel and unusual treatment or punishment. No law of Canada shall be construed or applied will deprive a person who has been arrested or detained of the right to be informed promptly of the reason of his arrest or detention, of the right to detain and instruct counsel without delay, or of the remedy by way of habeas corpus for the determination of the validity of his detention and for his release if the detention is not lawful. No law of Canada will authorize a court, tribunal, commission, board, or other authority to compel a person to give evidence if he is denied counsel, protection against self-crimination, or other constitutional safeguards. No law of Canada will deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of his rights and obligations. No, that sounds like an antiquated thing. No law of Canada will deprive a person charged with a criminal offense of the right to be presumed innocent until proven guilty. Let's just see about that. Freedom of the right, security of the person, and the right not to be deprived except by due process of law. Deprive a person of the right to a fair hearing in accordance with deprive a person. No law of Canada will deprive a person charged with a criminal offense of the right to be presumed innocent until proved guilty in according to law in a fair and public hearing by an independent and impartial tribunal. Note, or of the right to reasonable bail without just cause. And G, no law of Canada will deprive a person of the right to the assistance of an interpreter in any proceedings in which he is involved or in which he is a party or a witness before a court, commission, board, or other tribunal if he does not understand or speak the language in which such proceedings are conducted. Français, Anglais. Section 3. Now, so that covers the construction of the law. Section 3 of the Bill of Rights is the duties of the Minister of Justice, big note, and then Section 4 is the short title. Duties of Minister of Justice. Now that's basically telling him he has to audit stuff. Section 3, subsection 1. Subject to the next section, the exemption, the Minister of Justice shall, in accordance with such regulations as may be prescribed by the Governor and Council, examine every regulation transmitted to the Clerk of the Privy Council for regulation pursuant to the Statutory Instruments Act. Well, let's open that up. And every bill introduced in or presented to the House of Commons by a Minister of the Crown, in order to ascertain whether any of the provisions thereof are inconsistent with the purposes and provisions of this part. And he shall report any such inconsistencies to the House of Commons at the first convenient opportunity. Oh, that's so weak. Exemption. Subsection 2, pardon me. A regulation need not be examined in accordance with subsection 1 if, prior to being made, it was examined as a proposed regulation in accordance with section 3 of the Statutory Instruments Act to ensure that it was not inconsistent with the purposes and provisions of this part, part 1 of this bill. Short title, section 4. The provisions of this part shall be known as the Canadian Bill of Rights. Separate to the actual title of the Act. Part 2. Savings. 5, subsection 1. Nothing in Part 1 shall be construed as to abrogate or abridge or any human right or fundamental freedom not enumerated therein that may have existed in Canada at the commencement of this Act. Now that's probably looking at any sort of laws that were instantiated, like not. This doesn't override and negate any previously explicit legislative statements of rights or freedoms in others. So if it's some legislation said, oh, you do have the right to vote. All people have a right to vote. Well, this doesn't abrogate that just by saying that these are the declarations, recognitions of rights and freedoms. It doesn't override that. Okay, subsection 2. I also take that as to consider that realistically there are other laws or rights and fundamental freedoms that are not even enshrined in law, not said you do have this because of the nature of English common law. And this came into effect in 1960, before the constitutional amendment of 1982. If I remember correctly, that constitutional amendment somewhat severs the continuity of the House of Commons in the UK, or like a implicit pass-through, that laws that are enacted in the Commonwealth through the House of Commons in the UK have some bearing in Canada. Anyway, this is relevant for the previous to 1960. Law, which was also explicit, the British North America Act, something like that, which is a somewhat unspoken part of the Constitution of Canada. Law of Canada defined, subsection 2. This expression law of Canada in part 1 means an act of the Parliament of Canada enacted before or after the coming into force of this act, and or any order, rule, or regulation thereunder, and any law in force in Canada or in any part of Canada at the commencement of this act that is subject to be repealed, abolished, or altered. Okay, so that's just basically law of Canada is anything that's a law anywhere in Canada, inclusive at the moment when this is law. When this bill came into force, it affects all law of Canada, including that stuff which is subject to be repealed, abolished, or altered in the future. Jurisdiction of Parliament. This is a huge one. Big note here, and then we're done. The provisions of Part 1. The provisions of the Bill of Rights shall be construed as extending only to matters coming within the legislative authority of the Parliament of Canada. Big note. So we are now, I've just completed the reading of Part 2 and the whole of the Canadian Bill of Rights Act 1960 C44. One note, big note, that is, this does not affect in any regard like orders in council, the governor in council. It does not affect the rights that may be imposed upon arbitrarily by orders in council, unless they are, in the case, the key that, or the focus of my investigation and interest in Canadian law and reading it, is the beyond the general, just a general curiosity in reading for online sharing of really boring, dry stuff, or interesting but rare esoteric stuff, is the fact that the Canadians' human rights were trampled legislatively, philosophically, physically, and something like that. I'm not going to make a joke. So this doesn't affect the action of the exclusive action of the government of Canada. The government of Canada can do anything that is unrelated outside of this. This is only relevant for construction of law. It is hereby declared and recognized that there exists that in Canada there have existed and shall continue to exist without discrimination the fundamental rights and freedoms. So these are the fundamental rights and freedoms. And this is really only just relevant for the legislative authority of the Parliament of Canada. Very sad, isn't it? But the Parliament of Canada, affirming that the Canadian nation is founded upon principles that acknowledge the supremacy of God. So the supremacy of God and the dignity and worth of the human person and the position of the family in a society of free men and institutions. So this becomes relevant when you're looking at the Emergencies Act. And I should just call it quits right there. I would say that the preamble is, it doesn't say not operating notwithstanding, but it says, whereas the governor and council in taking such temporary measures in response to a national emergency would be subject to the Canadian Charter of Rights and Freedoms and to the Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, etc. for this piece, particularly with respect to those fundamental rights that are not to be limited or abridged, even in a national emergency. We know would be subject. Okay, the safety and security of the individual and the protection of the values of the body politic and the preservation of the sovereignty, security, and territorial integrity of the state are fundamental obligations of the government. Yeah, I think that I will always the fact that the invocation of the Emergencies Act in February 2022 was an act of I would, as a personal opinion, I would argue that was treasonous, and it's acting against the will, it's acting against the the integrity, it's acting against the security of the individual. It's acting against the supremacy of God and the dignity and worth of the human person, free institutions. I'd have to get into the legislation or the court cases against the Attorney General and the government for enacting that, but this reading is basically done. I want to thank, if you've made it this far, thank you very much, and I'm going to probably make a few more videos on Canadian law. Take care.